Good evening, everyone. Welcome back to another episode of Vital Dissent. I'm your host, as always, Patrick McFarland. This one is episode 260. Show notes may be found at vitaldissent.com/260. And in this episode, we're going to be talking about what to do to protect your children if you're in a custody battle and the child's other parent wants to have the children vaccinated, whether that's with the COVID-19 vaccines or with any other vaccines, and you're someone who's a vaccine skeptic. But before we get into that, I want to take just a little bit to talk about The Truth About Oppenheimer Part 1, which is the documentary that I released 2 weeks ago. And I didn't announce that I was going to be releasing it in the podcast feed. I just kind of dropped it. However, it is up and available on YouTube. If you're someone, one of the majority of people that only listen to the audio version of the podcast, make sure that you don't miss the actual video version of this documentary that was released on YouTube. Right now it has 8.5 thousand views. I've gotten about 500 new subscribers on YouTube for it. It's easily the most successful piece of media that I've ever released, and I'm very proud of it. I want to thank Mises Pieces, my producer, the guy who makes this show possible. He does all the editing and he posts everything, and he made this excellent documentary. If you'd like to go see it, it's free on YouTube, or just go to vitaldissent.com/Oppenheimer and you can go watch it right now for free. It's about 36 minutes long. I also wanted to say I will put in the show notes page that I was interviewed about the documentary by James Corbett. A lot of you guys are Corbett support listeners, as am I. That's how I decided to start making content, was being inspired from James Corbett. I was also interviewed by Scott Horton on the Scott Horton Show about the documentary, and I'm searching for more interviews to do as well. But a lot of you are following me now because you saw that documentary. I want to say that the best way to get the best access behind the scenes to my content is to go to libertyweekly.club and sign up for my membership website. It's an email list, so you can sign up for free. You can also choose the paid plan, and you'll be getting some bonuses there, like early access and some paid posts that I do as well. But just go to libertyweekly.club, hit that free sign up button to get. I've been trying to send out emails every day with some nice content for you, some links to follow and resources and some entertainment as well. And since there's so many more people that are doing it now, like 500 more people or 200 or 300 more people, I've been trying to breathe new life into that list and keep up with it, so that can be a good exclusive way to get access to my content. I don't use Substack. I use Ghost, and it's independent. It's something I actually control. So head on over to libertyweekly.club to get that. I'll put, again, all my interviews that I've done in the show notes page for The Truth About Oppenheimer. And if you want to help me pay my producer and to get part 2 out sooner than later, please go on over to libertyweekly.club, sign up, and choose a premium subscription there, $55 a year or $5 a month. If you do yearly, you get a $5 discount, a 9% discount there. So again, head on over to libertyweekly.club. I'll be dropping updates behind the scenes as I'm working on part 2, and some nice little stuff that you'll only get if you sign up for the email list. They'll be coming into your inbox. I'm going to try and do them every morning here. So anyways, thanks for that. I really appreciate everyone. Thanks to James Corbett. Thanks to Mises Pieces. Thanks to Scott Horton and everyone else, Dave DeCamp, and all these other people, all my Institute colleagues who've been helping me promote The Truth About Oppenheimer. So make sure that you go. It's a real, some people have said it's a Netflix, like it's worthy of Netflix. The production is so high that's the kind of content that we're putting out now, with your help and the help of all the people who help support my work at the Libertarian Institute and through libertyweekly.club. So that's the URL, libertyweekly.club. Just put that into your browser and you can find that content. So not to bury the lead at all here, thanks for sticking with me for that portion of it. But what do you do? There might be some of you who listen to this show who are currently in a custody battle, and you might be fighting over whether or not your child gets a vaccine, or the vaccine schedules, or the COVID-19 vaccine. And actually, this episode is going to be specific to vaccination and that issue. However, this actually does apply for any decision that you have with the parent of your child if you're in a custody battle, whether it's choosing which school that they go to or what their religion is or whether or not they can join the military might be a big one for you guys right now with everything going on in the news with Russia and China that I've talked about on this show before. So even though I might not look it right now, many of you may or may not know that I am a practicing attorney. I'm wearing, it's the weekend, so I'm not wearing a suit or anything like that. But I have handled several cases where decisions like this are at issue in the case. And I've taken 2 of them to trial, specifically over the issue of vaccination. Now, the first one that I did not, my client was not successful. And we'll talk about why in just a second. But the second one that I did, my client was successful. And we'll talk about why as well in this episode. So this is not legal advice. This episode is not legal advice. I can't tell you what you should or shouldn't do. All I'm going to do is educate you about the legal system and exactly what are the factors that the court considers when they're deciding whether or not a child should get a vaccine or not. And actually, that's kind of a mischaracterization because the courts, at least in Wisconsin, they do not actually make the decision about whether or not the child will be vaccinated. The courts make a decision by picking the parent who will make the decision. And that's a very important distinction because the court is not equipped to make those decisions, and it does not want to make those decisions because essentially that would mean that the government is making a parental a decision that is rightfully should be made by a parent. And if the court did have the authority to make decisions about what children are going to do, where they're going to go, then essentially that would be the government stepping into an area of private family life. And parents would have to go to the government, to the court system every time they wanted to make any related decision like that. And that just, the courts would be overwhelmed and swamped. I mean, that has also very Orwellian implications that you guys would be aware of. So I'm speaking from my experience specifically about Wisconsin law and what I've litigated in the courtroom. Other states might be different. I don't know if California is different. I do have friends that are practicing attorneys who do practice family law in California, so I would maybe ask them. But if you are doing it in Wisconsin, there's a few background things that you need to know about in order to even kind of grapple with these issues. So a lot of people will say custody when they mean placement. And so that distinction is very important. So if you're talking about the actual issue of custody, legal custody refers to making the rights, having the right to make decisions affecting the child's life. So it's defined under Wisconsin statutes. Legal custody means the right and responsibility to make major decisions concerning the child, except with respect to specified decisions as set forth by the court or the parties in the final judgment or order. So sometimes when you go through family law cases, it can be a bit of a choose your own adventure type thing. And what I mean by that is, generally speaking, the court doesn't want to make decisions for families like this about where the child's going to be, who's going to pick them up, who's going to pay for out-of-pocket medical expenses. The court doesn't want to have to come in and make those decisions because the court essentially has a cookie cutter, and they're going to take this rough cookie cutter and they're going to stamp it into the dough of your life and force something that's not specifically tailored to your family and your circumstances. So what the court wants to do is encourage you and the other parent of your child to come up, or, it could be a different arrangement in other circumstances, but to come up with something that's going to work, that's tailored, that you both voluntarily agree to, and not just something that the court is going to have a rough outline of whatever the court arbitrarily decides for your life. So again, major decisions includes but is not limited to decisions regarding consent to marry, consent to enter military service, consent to obtain a motor vehicle operator's license, authorization for non-emergency healthcare, and choice of school and religion. So again, today we're talking about legal custody and issues surrounding legal custody. Physical placement is what people usually mean when they say custody. Physical placement is the condition under which a party has the right to have a child physically placed with that party and has the right and responsibility to make during that placement routine daily decisions regarding the child's care consistent with major decisions made by a person having legal custody. So the court can give legal custody solely to one parent. It's not the norm. Normally, parties would have joint legal custody, which would mean that they both get an equal say in these major decisions. So it would mean mom and dad, you and your former spouse or your former partner or the parent of your child, that you would come together and you would discuss a decision. Let's say you want to have the child, or let's say the parties, you're in a situation where the other parent wants the children vaccinated and you don't, but they would need your consent to do that from the doctor's office. So the parent of your child would come to you and say, I want the child vaccinated. I'm afraid to go outside. Dr. Fauci says, oh, we just need to keep getting all these boosters and you're not going to be able to spread COVID. You're not going to be able to do those types of things. I want to have the child vaccinated. Okay, well, I disagree with that. I'm play acting as you would say, I disagree with that. Well, screw you. I'm going to do it anyways. Well, you can't because, that's not how this works. You got to get a court order. So your former, what's going to happen is that the parent of the other parent of your child, I'll just say the other party from now on. The other party is going to go to their lawyer or they're going to go to the clerk of court's office and they're going to file a motion. And the motion would be to grant them the authority to make the decision. So if you have joint legal custody, usually you can come together and have an agreement. But if you don't, then one parent has to be the tiebreaker. And in order to be the tiebreaker, they're going to have to file a motion to get the judge or the family court commissioner to award them power to make that decision and to pluck it out of the joint legal custody and cut out one small exception in that, well, we'll have joint legal custody except for the decision to make vaccines. To the decision to have the child be vaccinated, we'll cut out a small exception and give that authority usually to mom. Sometimes dad, but usually it's mom. That's just what my experience is. So once that motion is filed, then the court is going to have a hearing on it and see, what exactly we don't agree on. The court is going to read into that motion, but the court is probably then going to be appointing someone called the guardian ad litem. And a guardian ad litem is essentially an attorney that represents the child. So the child has their own advocate. And that attorney is going to be paid at your expense. And a lot of counties kind of set their own rules. In many counties that I've practiced in, each parent would have to pay $800 to the court, and the court will hire a guardian ad litem, and you'll be forced to pay the $800 because the court will say, okay, pay $800 within 30 days, and if you don't, then that's contempt. You're violating a court order, and sometimes you can apply for an exemption if you meet certain income requirements to have a guardian ad litem be paid for by public funds, but usually you're going to be forced to pay for it, even if it's the other party who is bringing the order, or excuse me, bringing the motion to get the order to have that decision-making authority. So this is all going to be a months-long process. So get ready for that. And you have the right, well, you don't have a right to an attorney, but you have the right to hire an attorney if you want one. I would suggest that you do, but I understand that in a lot of situations, people don't have, I mean, for me, I'd ask for a $4,000 retainer to handle a case like this, because usually they go to trial and $4,000, at the end of the day, it'd probably be $6,000 or $8,000 to litigate this issue from start to finish, from the first time you walk into my office to the motion being filed to going to trial and getting a result from that trial. That's just the way that the system is. It's time consuming, and it takes a lot of prep work and research and getting ready for a hearing and actually litigating the hearing itself. So once the motion is filed, if it's not part of a larger motion, so say this issue could come up in a regular divorce case where you're getting divorced, the children haven't been vaccinated for COVID-19, we're going to try to figure out decisions about, where placement is, what the custody will be overall, just not even regarding the vaccine issue, just in property division and all those things that go with a divorce. Or you could, maybe you had a one-night stand and now you're pregnant, or you got someone pregnant and you're not going to stay together, but that baby is going to be born. Now there's a paternity action that the mom brings to get child support from you and to determine who has parental rights to this child and who the legal, parents, who the father is going to be. So it could come up as a part of that, if you are having a new baby. There's all kinds of ways that you could end up in the courtroom where this would be an issue. It would be an action affecting the family. But sometimes it comes up, just because we have an existing divorce order and now the COVID-19 vaccines came out and mom wants the kids vaccinated and you don't agree. So we're just going to continue this episode as in presupposing that this is the only issue that's going to be litigated in the case, is this major decision-making authority to have the children vaccinated. So to recap then, there's a disagreement. You can't come to an agreement. Mom or other party, whoever wants the children vaccinated, files a motion. Attorneys are hired. Maybe they're hired before the motion comes. A guardian ad litem is appointed after maybe a first court appearance where the judge is familiar with your case. You get in front of him. You have your attorneys present. There's a guardian ad litem appointed. That guardian ad litem is going to do an investigation. And this is something that you should prepare for either with your attorney or if you don't have an attorney. And things that you need to be thinking about, because this is how the court is going to make its decision. Honestly, in a lot of situations, these custody cases, these legal custody cases are not incredibly common, even for experienced family law practitioners. I've come up because I've done speaking events where I talk about medical freedom, and people have come to me with their vaccine case issues because they know that I'm someone who is pro-medical choice, who's pro-freedom. And so they want someone like me on their side because I agree with them having that right. And some attorneys don't. I mean, you know how political things are. So they have come to me, and sometimes the guardian ad litem doesn't fully understand that the court, and even family law attorneys don't understand that the court is not there to make a decision. Should this child be vaccinated? Should this child not be vaccinated? That's not the issue. The issue is which parent is most likely the one that's going to make the right decision for these children in their best interests, because the best interest standard is like the golden rule in family law cases. What is in the children's best interest? That's what the court wants to do. But in doing so, they're going to pick the parent who's most likely to make the correct decision. So when you're preparing for that final hearing and when you're preparing to talk to the guardian ad litem, because as part of the guardian ad litem's investigation process, that guardian ad litem is going to talk to your attorney, they're going to talk to you, they're going to order medical records, they're going to, if the children are old enough, they're going to talk to the children and try to figure out exactly what their wishes are. And factor that into their decision as much as it is appropriate to do so. But if they're thorough and they're doing their jobs, they're going to be doing this investigating. So they're going to interview you, they'll interview the kids. They might even call and talk to their doctors. They might order the medical records. They might order school records, possibly for the vaccine issue. And they're going to do all these different things in this investigation. And for you, at that preliminary point in the case, after the guardian ad litem has been appointed and is doing the investigation, for you need to be doing your homework. You should have already done your homework even before you got to the point where now you're hiring lawyers and there's a motion pending about vaccine cases. And if if you are at a point where you haven't done any research and you haven't been involved in your children's medical lives, their health, you're already in trouble, and you're probably going to lose, to be honest, because the way that you win a hearing like this is to be incredibly involved in your children's lives. That's just the way it is. And I'm not saying that that's particularly fair, because in a lot of relationships you have delegation, right? I mean, in my case, you know, I'm an attorney, I'm busy. I don't always have the time to go to my children's doctor's appointments. I do make it a priority, and I go to as many of them as I can. But if there's an important case that I have scheduled, and, you know, one of my kids has some kind of I don't know, just a regular appointment, or if it's something where, you know, the new baby isn't latching right with breastfeeding, I can't drop everything and go to the, you know, that appointment for breastfeeding, the lactation consultant. That is the reality. And I know a lot of people don't have the flexibility that I have being self-employed to do that. I mean, you have an 8 to 5, you got to be at your desk. You only have so many sick days, personal days. You don't always have the time to drop everything and go to the doctor's appointment, talk to the doctor, coordinate with your partner, or your former partner even, and to be that involved. But those are the things, even more so than, oh, did you read through all of the CDC health information in the American Academy of Pediatrics? And did you read the vaccine, the Jeremy R. Hammond books, or there's a digest that's just not coming to me right now where has all of for vaccines, it has all of those critical scientific studies that are summarized in it. I don't know if it's Dr. Brown's Digest or something like that. The court is not going to care about whether or not you've done your research and what the overall issue is. The court is going to care, have you, when you found out way back when your child was conceived, when you found out that your child was going to be born, did you go to those pregnancy appointments? Did you go to all the wellness checkup? Were you there at the birth? Were you talking to the doctors? Were you there before the birth talking to the doctors, making decisions about whether or not to do genetic testing for your child to screen for, Down syndrome and all these chromosome disorders? Can you articulate who your doctor, your wife's or your partner's gynecologist was, or OBGYN, not gynecologist? Do you know their name? Have you talked to them in the past? So you're kind of getting the picture of where I'm going with this. Once the child was born, did you make the decision about circumcising with a boy? Or, did you make these decisions about maybe the child's bilirubin levels were high? And were you there when they put them under the UV lamp? Or did you go to the next day after the birth? Did you go to that checkup appointment? Did you go to the 2-week appointment? Did you go to the month appointment? Did you go to the 3-month appointment? Did you talk to your doctor? Did you request the vaccine inserts? Did you go and get the brochures for, the ones they hand out at these appointments telling you about how great vaccines are? Did you do all those things? Because those are the most important things to have done. And if you didn't do those in the past, then you're in trouble. And if you're a working, you're probably a dad. I mean, most of the guys who listen to, most of the audience of my show are all men. So you probably are doing an 8 to 5. You're probably at the desk. You're probably working hard. Maybe, you're out trimming trees, or you're out working as a lineman, or doing all those things, or a truck driver, and you just can't make it to the doctor's appointments. You're already behind the 8 ball. I mean, just the way that it's set up, it's unfortunate, because men should be able to go do these things and fend for their family and have that, division of labor with their partner, that your partner is the one who helps to facilitate these things. Maybe your partner's staying at home with the kids, things like that. So when you're getting ready for that guardian ad litem appointment, if you've done those things, then you need to document those things and get as much evidence that you can of you being there, whether that's anecdotal, a testimony that you can give, or whether it's doctor's notes, or if it's any piece of evidence. If you have text messages saying that you were there, if you have phone calls to the clinic, if you have, all this evidence of you setting up appointments and being involved in your child's medical life. That is the gold right there. Now, you also want to be doing your research. I mean, and not just YouTube videos either. You should be reading actual research articles. You should be reading the digest I was talking about earlier about vaccines. I'll try and maybe I'll put a link in the show notes page if I can remember. But you should be doing all those things to prepare yourself. And once you talk to the guardian ad litem, you tell them about all of your involvement in the child's life. You tell them about the cost-benefit analysis. And I think it's very important to put things in that kind of perspective. Talk about the benefits of maybe getting vaccinated. And maybe you can't see any. And if you don't, I guess that is what it is. But try to think of some benefits. But if you're at the point where, I mean, you're dead set against it, that's going to be really hard to do. But it's critical that in your thought process, and I mean, maybe you could, it is better if it seems like you came to it with an open mind, that you hadn't made up your mind before looking at and doing this cost-benefit analysis. Because, I mean, for so many of us, it's like, well, over my dead body, is my child going to get the vaccines or any, it's a personal issue like that. Maybe you've already made up your mind, but at least come to it doing your research, saying that you're not 100% having your mind made up, that you're going to look through it, and that data that you look through is going to, in the cost-benefit analysis that you do, is going to affect the decision in some way, shape, or form. That is ideal. So when you get on that stand, on the witness stand, and your attorney or you pro se maybe without an attorney are just talking about all the things that you did to be involved with your child's life, how you approached this decision, how you knew that even though you had personal convictions, that you still took into account what was best for your child by doing this cost-benefit risk analysis is very important. And the guardian ad litem is going to conduct the investigation, do the interview of you, pull all these things together, talk with your attorney, and write a recommendation. And that recommendation is going to be their thoughts on who is most likely to make the decision that is best for that child. The most relevant thing for that is going to be who's been making the decisions in the past, and have those decisions borne out. Have they created a healthy, well-balanced child that has been medically cared for and is, doing well in those respects? Another thing to do, I forgot to mention this, is to talk to your child's pediatrician. If you haven't done that already, which you should be doing as a parent, just regularly by going to these appointments as much as you can. And if you can't make it to those appointments, call your doctor and talk to them yourself about how the appointment went and what they think about your child. And if you have questions, ask those questions. If you can't make it to the appointment, maybe you could have a phone call with, be on the phone during the doctor's appointment. That's super important. I mean, again, these are things that you should be doing anyways in being involved in your child's life. But specifically about the vaccines, talk to your doctor. Your child's doctor is probably not going to want to write a letter evidencing either one way or another. But sometimes you have a doctor who is totally okay with respecting your right not to vaccinate your child. And if you have a pediatrician who does respect that and is willing to write a letter saying, we've discussed the pros and cons of having the child vaccinated at this time, at this time, your child's, the parent is not willing to vaccinate, and that's fine with me. That letter would be excellent. I mean, it's hearsay in the court unless the doctor can come in and testify it, or there's another exception to hearsay, which hearsay is simply, it's an out-of-court statement offered to prove the truth of the matter asserted. So if your doctor writes a letter saying, well, Jimmy's a healthy boy, he doesn't need a vaccine, dad is against it, and I'm fine with that. If you bring that into court and offer it to the judge saying, look, the doctor says that I don't need to vaccinate my child, she's on board, it's all hunky-dory, well, that's hearsay, because It's an out-of-court statement that's being offered. It's an out-of-court statement saying Jimmy's okay not to be vaccinated. It's being offered to prove the truth of that statement, and there's no foundation there for, you're not bringing the doctor into court to say those things. You have a letter that was written outside of court. The foundation can't be established without bringing that doctor in or having another exception to hearsay, which could be, possibly could be a record taken in the normal course of business. That's an exception to hearsay. So you could argue that to the judge, or you could just say, Your Honor, I'm presenting, or your attorney could say, Your Honor, I'm presenting this letter. I'm not offering it to say that Jimmy's fine not to be vaccinated. I'm not offering it to say that the physician says that. I'm offering it to say, hey, look, I did my due diligence by talking to Jimmy's doctor, and I got this letter from the doctor. So it just goes to show that I'm doing my homework and being prudent. You can offer it for that limited purpose. So at this point that the guardian ad litem has done the investigation, has written the recommendation, you're going to get the recommendation, and it might say, Dad has been prudent, he's been involved, but Mom is the one who's been most involved and is most likely to make the right decision. In that case, you're going to have to go to trial, because I'm assuming your dad here. At that case, you could either accept it and give her the authority to vaccinate your child, or you can take it to trial. And it's really hard to split those hairs. If you have been as involved as you could be, but Mom, just by nature of being Mom, has taken the kids to all the appointments, has been the czar in a way, the person appointed to facilitate the children's health care, she is just going to have that advantage, and there's nothing really that you can do about it. And if you have been doing as much as you can to be involved to that point, you might be able to win still by going to trial and by demonstrating that you've done your homework more than she has. So if you're a father who has never been involved in the children's appointment, you can't remember what their pediatrician's name is, you can't remember the last time you spoke with them, you can't remember the last time you were at a doctor's appointment even, then you're in trouble and you're going to lose. And you might as well save your money, cry yourself to sleep and lick your wounds, and put up with the fact that your child is going to have the vaccine, because you're not going to win. But if you have been, like I said, as involved as you can be, if you can go to that hearing and demonstrate that you've done your homework more than Mom has, and if Mom gets up there and just says, and this is what she'll probably say, well, the doctor says, and the CDC says, and the American Society of Pediatrics, or the American Academy of Pediatrics says, vaccinate your child, then you can get up there and talk about all the research that you've done, that you've talked to the doctor about it, that I'll talk about in a second the way that you can present the research in a way that it's going to be somewhat effective. But again, you get up there and say, I've been as involved as I can be. Here are these facts about my child's life. Specifically with the COVID vaccine, talk about, how COVID's pretty much over, how it's not really an issue in public health as much as it was 2 years ago anymore. It's not required to go to school. There are 2 children who died with COVID in Wisconsin. Specifically in Wisconsin, if you go on the Wisconsin state website, the Wisconsin DHS website, I believe it is, you go there and you look at child fatalities from COVID. With COVID, it's 2. There's 2 children, and I hope that YouTube doesn't strike me for this as misinformation or anything. Now I'm gonna have to cite it, put it on the screen so they don't just automatically block it. But it's a very small number. It's less than 10 of children. And so you say those things and you talk about the risks. You could bring up VAERS, which is hard to get in evidence-wise. I couldn't get it in a hearing. But getting in the VAERS statistics is hard to get in. It has limited relevance just because they don't screen. It's kind of speculative because VAERS doesn't include any specific information, and they don't do a lot of verification of what these complaints are. They're voluntary reports. So it's hard to get that kind of information in. But specifically when you're presenting your research, I think the most effective and economical way to put it in and put it on the record is to know it well enough to summarize it briefly in a few sentences, but to put it together in a packet. So you have all your resources together, you put it together in a multi-paged packet, and you introduce it to the court as one exhibit. And that way, when you're on the stand, you can, your attorney will come up and show it to you. It'll be marked by the clerk as an exhibit. Your attorney will come up and say, so I'm handing you what's been marked as Exhibit A. Do you recognize Exhibit A? Yes. And you say, well, what is Exhibit A? Your attorney will say, and you'll say, well, Exhibit A is a packet of research that I assembled, that I reviewed and put together, that I reviewed myself when I was making the decision not to vaccinate my child. And so your attorney will say, well, what's the first document in this packet? And in this document, just as an example, you would say, this is the whatever study that shows that whatever mortality, however risk benefit. Okay, next one. This is the study that shows XYZ, yada, yada, yada. And the next one, this is the mortality statistics that I got from the Wisconsin DHS about children and how at risk they are for having severe complications from COVID-19. Okay. And you might get an objection at that point because it's all hearsay. I mean, you can't offer the studies to prove the underlying points because one, you're not an expert. Two, it's all hearsay. And three, the court, it has limited relevance because the court isn't going to make the choice, remember, about whether the child should be vaccinated or not. The court wants to pick the parent who's the most qualified and the right person to make the decision with the right track record. So when you get up there and you're talking about it, just know that the judge probably doesn't even care about what is said in the documents being true or false. Certainly the reliability and how reputable the sources are is relevant to some degree. I mean, if you get up there and you have like crazy wacko, like conspiracy theory things like from a Substack post, like if you come up with Alex Berenson, I'm not saying that that's what his stuff is. I'm just saying don't go up there with a printed out Substack article. Okay. That's all I'm saying. It's no judgment on those individuals and the work that they've done, but don't go up there with a Substack article. I mean, if you have a peer-reviewed research paper, that's way better. But you're offering it not to prove the truth of what they say. You're offering it to say, look, this is the reputable research that I did in making an educated choice for my child's safety and health. That's what it's there for. So again, the guardian ad litem comes out with their recommendation, and if it's bad for you and you're not going to give up on your child, then you go to the hearing. And at that hearing, be prepared to testify about and to ask questions of the other party or have your attorney do so of who's been involved in the child's life, who's been making the decisions in the past, how have those decisions gone? How involved has that person been in the decision-making process? How educated were their decisions? What was your cost-benefit analysis? How did you form your opinion about the vaccines? How did you make a choice about this vaccine? What has your child's health been like? When are they getting it? How old are they? What activities do they participate in that might make them susceptible? What is their health history? How does this vaccination make sense in terms of their health history? How would it affect that? Have you spoken to the child's doctor? Have you done all these things? So, I mean, you could come at it from so many different angles. And if the other party's on the stand and you don't have an attorney, you have a right to cross-examine them, or your attorney does. And you should be asking them, close-ended questions, right? Close-ended questions where it's either a yes or a no answer, and phrase the question in terms of a statement. It's not really a question. So if it is, let's say that you're the other party, your former partner, or the other parent of your child, if they haven't gone to any doctor's appointments in the last 6 years, you could say, well, isn't it true that the last time you went to a doctor's appointment for our daughter was 2016? Or you could say, I think it's probably better just to say, now you haven't been to a doctor's appointment since 2016, and you don't know our child's doctor's name, and you haven't spoken to our child's doctor since you went to that appointment in 2016. So questions like that, where they say either yes or no. And if they try to, what they'll try to do sometimes, especially if they hate you, is they'll try and wiggle around it by answering and then having an explanation. And that makes them look a little less credible, but sometimes they try to get damaging information in that way. And if they keep doing it over and over again, maybe after the second or third time, you just say, Judge, can you please instruct the witness to just answer with a yes or no? Because that's what a cross-examination is. At times, I've interrupted people and said, please just answer the question. Just yes or no. It's a yes or no question. Just answer the question. And if they keep doing it again, then you ask the judge, please instruct the witness to just answer the question. So you try to set up your questions in the form of locking them into an answer, because when you ask a question on cross-examination, you want to know what the answer is before you ask the question. You should know what the answer is. And if they lie or they try and wiggle on it, you should have some kind of means of disproving what they're saying. So if they lie, they say, let's say you say, you haven't been to a doctor's appointment since 2016. And they say, yes, I have been. You're wrong. And you know that they're lying because you have, the attendance record from the doctor's appointments. And you can say, well, Judge, may I approach? And you can approach with the list and you have it marked and you put it in front of them and say, okay, now your testimony is that you attended the doctor's appointments. I'm presenting you with, rebuttal exhibit, whatever. Do you recognize this? Well, what is it? And is this, isn't this a document from our healthcare system saying who attended the doctor's appointments? Yes. And your name isn't on that list, is it? No, it's not. And that's because you haven't attended any doctor's appointments since 2016. Okay, moving on. And don't really dawdle your time with it, but just be direct and try not to be vindictive either. Just be matter of fact. And I think that's the correct way to do it credibly if you're representing yourself. If not, let your attorney do it. And moreover, trust your attorney. You should. And if you don't, then just fire them, because there's no point in hiring an attorney and trusting them to do the job that they are professionally, engaged in a career in doing, and hiring them and then wanting to dictate how they do it. If you want to do that, then just represent yourself. There's no use in paying someone else to do a bad job. So that's kind of it. So if you get into the hearing and you go through all the testimony and you addressed all the things specifically of what I was talking about, not trying to convince the judge of your viewpoint about vaccines and how ineffective they are or how dangerous they are or untested. And you could ask questions too about, how long has this treatment been around, and those kind of things, and kind of make your points that way and talk about experimental treatments or how long treatments have been around that we don't know the long-term effects because they haven't been around very long, and that's not very safe. And the risk is low, and the risk from COVID-19 is basically, you can make this point that the risk from COVID-19 is, sorry about that. The risk from COVID-19 is less than the vaccines, because we know what the risk from COVID-19 is, but the risk from the vaccines is a big question mark still. So those are points that you can make. But remember, keep in mind, the judge doesn't want to make the choice. The judge wants to pick the better parent. So make yourself the better parent. You should have been the better parent this whole time, but if you haven't, there's some ways to recoup that. Then when you get into the actual legal arguments, at least in Wisconsin, there is, I'm going to bring up the statute in a second, but there's a statute that says if there's a disagreement about a decision, a major decision, then one parent can petition the judge to delegate that authority to one parent. All right, so under Wisconsin statutes, it's 767.41 considers custody and physical placement, and there's a lot of information here, and family law statutes in particular are kind of known for being like the procedure is complicated in all these factors. There can be a lot of superfluous, well, I don't know if it's superfluous, but confusing language to go through. So we already talked about what custody and placement are. But if you go down 767.41 sub 5, so for the video version, if you're watching, you can see I have the statutes up here. Factors in custody and physical placement determinations. So this tells the court specifically and the guardians ad litem what the factors are in making the decisions that I've been talking about here. They're not necessarily listed in order of importance, though. And at the bottom it says, well, the court can consider any other factor that it deems like relevant. So, but here's the wishes of the child's parents or parents as shown by stipulation or proposed parenting plan. Basically, that's why they interview you. The wishes of the child if they're old enough. So if your child's old enough to say they don't want to be vaccinated. The cooperation and communication between the parties and whether either party unreasonably refuses to cooperate or communicate with the other party. So it's also important as this process is going on to listen to your former partner and to be able to show that you have listened in the future, that you took their arguments under consideration. And it's even, I think, effective to be able to say in court to accurately articulate the reasons they're saying why they want the child vaccinated. Because in doing that, you're showing, according to this factor, that you are able and that you're reasonable, that you're able to listen, that you will consider their wishes as a part of making the best decision for your child. You appear to be more reasonable when you can say, yes, we sat down, we had an intelligent, polite discussion. Maybe you say we sat down and they were getting angry and I was listening and I was trying to, be polite, but they got angry and they left. Maybe that's what happened. But if you can articulate the reasons why they're objecting, maybe they're not good reasons, but if you can honestly and fairly say that, you're going to come across as being more credible and being more cooperative in trying to make and collaborative in trying to make this decision for your child. So 4, whether each party can support the other party's relationship with the child, that's not quite as applicable. The interaction and interrelationship of the child with his or her siblings, not exactly applicable. The amount of quality time that each parent has spent with the child in the past. Any necessary changes to the parent's custodial roles and any reasonable lifestyle changes that a parent proposes to make to maximize placement. So this is kind of placement, but this amount of quality time and changes to the parent's custodial roles, they're important history in the case. I don't know whether any following has had a significant problem with drug or alcohol abuse, a party or anyone that you're involved with, anyone who lives in your house or with the child. That's not exactly applicable, but could be. The child's adjustment to the home, school, religion, and community is important in custody decisions for custody for decision making. Maybe there's, a new doctor or something like that, how they've adjusted to the new doctor. But that primarily this factor has to do with placement primarily. The age of the child and the child's developmental and educational needs at different ages. So again, that's more so placement, but it could be relevant in terms of, what are their needs? How old are they? What are their needs at these different ages and in terms of healthcare specifically? And this also goes with transgender issues too, transitioning children and seeking medical care to affirm, they call it gender affirming care. But everything that I've said, just copy paste and apply it to that issue as well. It's also applicable. So the reports of appropriate professionals, if admitted into evidence, you don't want to hire a doctor. I mean, if you have tons of money to spend, you could hire a doctor to come in and opine on this. But again, the court doesn't care. The court does not care. The opinion of the child's treating physician is going to hold so much more weight than any expert that you could hire or any doctor you could hire to have a second opinion. If you do hire a doctor to have a second opinion, have your child actually meet in person with that doctor to get an examination and not just say, well, because your child's treating pediatrician is still going to have a higher weight than somebody that you hired just to examine them once and say, nope, they don't need a vaccine. So, but you do not want to get into a position where you're paying doctors thousands upon thousands of dollars to come into court and giving an opinion that the judge doesn't even really care about, or has a limited relevance in terms of which parent is going to be more suited to make this choice. And so those are the factors. Again, any other factor that the court determines to be relevant. But if you go to 767 point 51, 767.41 sub 6, final order, AM, so 767.41 sub 6, A parent AM, in making an order of joint legal custody upon the request of one parent, the court shall specify major decisions in addition to those specified under 767.0012M. So we read that earlier, the definition of major decisions, but the court under that parent, let's see, 767.41 sub 6 AM. So this is the statute that gives the court the authority to give one parent the ability to specify major decisions, to make that decision. Because you might get into a situation in court where, and I've been in this situation very recently, where another attorney didn't understand how the court had the authority to make this designation. And this other attorney was of the opinion that the court had the ability to make the decision and confuse the issue, saying that the court had the ability to say yes or no vaccine. And that's not true. Under this statute, it's 767.416 AM in Wisconsin. It says the court, upon request of one parent, the court shall specify major decisions in addition to those specified under 767.001 sub 2M. So that is giving one parent the authority to make the decision. It's not making the decision. And that's such an important distinction to be made. And I would assume that most courts follow the same type of structure as this. Again, I don't know. So whatever state you're in, I would encourage you to consult with an attorney. And again, this isn't legal advice. This is just education about my experience in the court system and my experience litigating these issues to trial in cases. So I hope that you found this useful and that it was chock full of good information for you to have knowledge about the best way to be involved in your children's lives, to be the best parent that you can be. And in the future, if you're in a situation where things are splitsville with you and your child's parent, and you're worried about stuff like this, I mean, first off, you should be still as involved as you can be in your child's life in terms of all these things affecting decisions and their care and comfort. But start documenting evidence about how involved you've been if you think that this is going to be an issue. And I mean, this is duly applicable to vaccines, or if there's like trans care or any of that gender stuff, and you and your former partner don't see eye to eye, just be prepared. Know that these are going to be issues. So, all right, guys. Well, thanks so much. I hope you enjoyed this. I hope you find it useful. Again, if you like my work and like this episode, go on over to libertyweekly.club, sign up for my email list. You can do it for free. libertyweekly.club. Go and hit the subscribe button in the lower right-hand corner. You can pick the free subscription here if you'd like, but if you'd like to actually support my work and want to help me put out Oppenheimer, The Truth About Oppenheimer Part 2, head on over to the right-hand side. Either choose a monthly or a yearly subscription, monthly $5 a month, or annually $55 a month. Sign up there. Just put in your name and your email, and you can help support this content. Help me pay my producer, my great producer, Mises Pieces. And yeah, we'll look forward to the next one. I have an interview coming up on Thursday with Brandon Buck. He writes at the Libertarian Institute. He's a PhD history candidate, I believe, and also he writes at Responsible Statecraft. So we're going to be talking about the old right and the anti-war roots of the old right, and an article that he wrote for the Libertarian Institute. Again, sign up for that email list, and I'll be putting out content pretty much every morning. So, all right, thanks, guys. Peace.